Thank you very much for joining us today. It's great to see so many people have dialed in. In order to minimise background noise, please can everyone make sure they mute themselves. Please do, however, feel free to ask questions via our chat function. We do have a lot to cover today, so apologies in advance if we don't have time for lots of discussion, but I'd be very happy to pick up offline with anyone who's interested. Our contact details will be shared. Lastly, today's session will be recorded and circulated afterwards in the usual way. So the plan for today is to update you on the latest news in terms of employment law reform under the new Labour government. My colleague Vincent Chung will then do likewise from an immigration perspective. And lastly, our Ross Mackenzie will give a very brief update on case law. So turning now to the election result. Well, I hope you've had your porridge like me and have a comfy seat because I've got quite a lot to get through in a short space of time. Labour's landslide victory on the 4th of July means that we can expect to see some truly radical changes to employment law. We anticipate that the next couple of years will be a very busy time for HR, employment lawyers and in-house legal teams. It's no exaggeration to say that the reform we see under Labour government has the potential to mark the biggest changes to employment law that we have seen for quite literally decades. The proposals are far-reaching and touch on almost every aspect of employment rights. So I think it's fair to say that Labour is going to keep us all very busy. We covered some of Labour's key proposals at our last law webinar. Since then, we've had the state opening of Parliament and the King's speech just last week. As part of that process, the Prime Minister provides briefing notes which offer slightly more detail on how Labour plan to go about implementing their pre-election promises. The briefing notes are lengthy, running to 104 pages, and cover all aspects of their manifesto, from health, national security, etc. So the detail on the employment reform is still limited. And to be honest, we still have considerably more questions than answers at this stage. But in short, there are two new pieces of legislation, at least in the first instance, to be aware of. And those are, firstly, the Employment Rights Bill, and secondly, a draft Equality, Race and Disability Bill. So the Employment Rights Bill is to be introduced to Parliament within the first 100 days, and Labour states this will represent the biggest upgrade to workers' rights in a generation, so a bold claim to say the least. The briefing note states that the Employment Rights Bill will deliver on the policies set out in Labour's plan to make work pay paper that will require primary legislation to implement. I shall go on to consider some of these in more detail, but before I do, I'm going to touch on what is not in the bill, or at least not referenced in the King's speech. The Employment Rights Bill does not contain anything regarding Labour's previous proposal to move towards a two-part system for employment status of workers on the one hand and the genuinely self-employed on the other, thus ridding ourselves of the confusion caused by questions of employment status. The government appears to accept that this proposal will involve substantial change and consultation will be required prior to any change to the employment system. Therefore, this is a change we expect might take some time. However, in the briefing note, it does refer to certain new rights in the Employment Rights Bill being available to workers. For example, the right to claim unfair dismissal from day one, which I'll come back to later. However, as you'll be aware, unfair dismissal protection is only applicable to employees. Therefore, the government's intention on the timing of the new Employment Rights Bill being brought into force and reforming the employment status system and how these two will interact is unclear. Also, Labour had previously said they would introduce the right for workers to switch off. However, again, this is not mentioned in the King's speech. Likewise, Labour's previous proposal to reverse the Woolworths decision so that collective consultation requirements will be triggered if redundancies reach a defined threshold across the business as a whole, as opposed to just looking at numbers in each individual site, was not mentioned in the King's speech. Also, nothing was said about Labour's proposal to increase tribunal time limits from 3 to 6 months. So time will tell if and when Labour plan to tackle these points, whether it be in the draft bill once we have sight of it, or at a later stage through separate legislation. So turning now to what the Employment Rights Bill does propose to do. Well, as I touched on, Labour have stood by their commitment to introduce basic individual rights from day one for all workers, including unfair dismissal, parental leave and sick pay, which is one of the biggest headlines pre-election. What does this mean in practice? Well, for starters, it means I won't get to ask every employment lawyer's favourite question of what service do they have, because the reality is it won't matter. The fact that Labour want to change the qualifying period is not surprising. It's been a political potato that seems to have been impacted at every change of government, but the proposal to eradicate it altogether really is radical. As long as unfair dismissal protection has existed in the UK, there's been a qualifying period. The shortest time it was ever reduced to was 26 weeks when Labour were in government in the 1970s. Likewise, the proposal to extend the right to workers is significant. After all, the reason a lot of employers engage workers is to retain flexibility and limit their exposure to such employment protections. The impact this may have on the gig economy in particular is likely to be vast. The policy reasons behind this change is that Labour say extending protections to workers from day one will encourage more workers to switch jobs, which is associated with higher wages and productivity growth. Apparently, according to Labour, wage rises are around usually 3 times higher for those who move jobs compared to those who do not. If this is the case, the reform will bring significantly increased costs for employers, not just in terms of wages, but also recruitment. And I imagine even more effort will have to go into identifying the right person for the job. Employers will also need to really focus on the retention of workers in order to keep recruitment costs down. From a practical perspective, it will also mean a greater reliance on the use of probationary periods. Whilst the use of probationary periods is confirmed as permitted in the briefing note, it offers no more detail. Perhaps Labour will set a limit on the duration of probationary periods or how much leeway employers will have to dismiss during this time. Presumably, some sort of restriction will be necessary to ensure employers don't exploit this option and undermine the day one right. Notably, the Labour's plan to make work pay paper previously provided that the changes will help to ensure that newly hired workers are not fired without reason or cause. This suggests some kind of set reason may need to exist for dismissal even during the probationary period. So if your company does not currently have probationary periods in their style employment contracts, it should consider inserting these for new starts going forward in anticipation of this major change. Next up, Labour say the Employment Rights Bill is to ban exploitative zero-hour contracts, ensuring workers have a right to a contract that reflects the number of hours they regularly work and that all workers get reasonable notice of any change in shift with proportionate compensation for any shifts cancelled or curtailed. What is notable with this proposal is how Labour's position on this has changed slightly. Originally, Labour claimed that they would ban zero-hour contracts, but now it seems that rather than ban them, they will give individuals the right to request contracts to actually reflect their regularly worked hours. It appears Labour may have realised that some individuals actually like the use of zero-hour contracts, and flexibility can be a benefit both ways, and they have watered down their original commitment. Indeed, in the briefing note, Labour say this will end one-sided flexibility, ensuring all jobs provide a baseline level of security and predictability. So it seems their efforts are more focused on ensuring a more level playing field. If that is the case, it is not clear how Labour's proposed reform will differ from previous Conservative plans and the new regime on the right to request a more predictable working pattern, which was already due to be introduced this autumn. Under this regime, similar to flexible working, employers will be able to refuse a request for predictable working pattern on certain statutory grounds. Of course, limiting the use of zero-hour contracts may create resourcing challenges for a number of businesses. However, Labour have previously said fixed-term contracts will still be permitted, so we may see a greater use of these, for example, in terms of managing seasonal fluctuations, perhaps in conjunction with the use of overtime. Again, there's no more detail on this change in the briefing note than we already know, and there's no mention of fixed-term contracts. It would therefore be worthwhile for employers to conduct an audit of their use of zero-hour contracts at present to understand how any change may impact their business. No doubt the use of zero-hour contracts is more prevalent in certain industries, so some businesses will be harder hit than others. Moving on, in terms of flexible working, Labour have said they shall make flexible working the default from day one for all workers, with employers required to accommodate this as far as is reasonable to reflect the modern workplace, so more than just a right to request. The flexible working regime was already expanded in April this year when it was made a day one entitlement, and the number of requests employees could make in a 12-month period was increased from 1 to 2. However, currently an employer may still refuse a flexible working request if they believe that one or more of certain ground applies. But there is no requirement in the legislation for this belief to be reasonable, and little scope for employees to challenge an employer's decision. It therefore appears that some form of reasonableness test will be introduced under Labour. We understand that there will be exemptions for jobs or sectors that are time critical or where shift patterns mean that flexible working is not suitable, but again, we don't yet have more detail. Next, Labour have said they intend to strengthen statutory sick pay. They plan to do this by two means. Firstly, removing the lower earnings limit to make it available to all workers, and secondly, removing the waiting period so that people benefit from it from day one and do not have to wait until the fourth day of any absence in order to receive pay. According to Labour, currently 1.5 million people earn below the lower earnings limit, which is currently £123 per week. Their view is that the current statutory sick pay regime disproportionately affects the lowest paid workers working part-time or in low-paid multiple jobs. Of course, this will come at a greater cost to employers, although arguably these changes will be easier to manage from an admin perspective. Next, Labour have said they plan to end the practice of fire and rehire and fire and replace by reforming the law to provide effective remedies. We had already seen some change in this area under the last government. The Code of Practice on Dismissal and Re-engagement, introduced by the Conservative government, came into force just last week. However, the code does not itself make an employer liable to legal proceedings if they do not follow it. In other words, there's no standalone claim. Similar to the ACAS code, it can be taken into account in legal proceedings, and if there is a failure to follow the code, a tribunal can increase any award it makes by up to 25% if the employer has unreasonably failed to comply with the code. Now, whilst a tribunal can award an uplift for certain claims, for example, unfair dismissal, draft legislation to allow a tribunal to uplift a claim for a protective award for failure to follow collective consultation obligations in a redundancy situation did not make it through in the wash-up period and will require to be brought in by Labour if that specific power is to take effect. Again, similar to the position in respect of zero-hour contracts, originally Labour claimed that they would ban, fire and rehire, but now they have said it is important that businesses can restructure to remain viable, preserve their workforce and the company when there is genuinely no alternative. But this must follow a proper process based on dialogue and common understanding between employers and workers. It is clear now that they intend to replace the statutory code and introduce stronger penalties for employers who breach their consultation obligations. Whilst we await further details of these changes, employers should at least ensure that they are familiar with the new code of practice when considering making any changes to terms and conditions of employment, as it remains the law unless and until it is changed. Next, Labour have said they intend to strengthen protections for new mothers by making it unlawful to dismiss a woman who has had a baby for a period of 6 months after her return to work, as opposed to simply obliging the employer to offer her alternative employment where there is a suitable vacancy, except in specific circumstances. Unfortunately, no detail has been provided as to exactly what these exceptional circumstances might be. Further, it appears that the intention is for this right to only apply to new mothers, which could lead to potential discrimination claims from same-sex parents taking adoption leave. Commentary suggests that what this will likely turn into is a requirement for employers to demonstrate the dismissal of such an employee is genuinely for a reason that has nothing to do with pregnancy or maternity. However, since employers should already be very cautious of dismissing women returning from maternity leave due to existing discrimination risks, the extent to which there will be any real change in this area remains to be seen. One of the more notable changes from Labour, which they've described as a key priority, includes establishing a new single enforcement body, also known as a Fair Work Agency, to strengthen the enforcement of workplace rights. The briefing note states that this body will have the power to enforce workers' rights, including stronger powers to inspect workplaces and issue fines. It'll undertake targeted and proactive enforcement work and be able to bring civil proceedings upholding employment rights. Prior to the election, Angela Rayner, now Deputy Prime Minister, said the new body will have real teeth. This could bring about a real seismic change where workers can make complaints to a body which can investigate and bring proceedings against employers, meaning it will no longer only be up to employees to hold employers to account. It may be similar to how HMRC approach enforcement of the national minimum wage. The exact remit of the body is unknown. On a related point, Labour have said they will also take steps to strengthen and improve enforcement through employment tribunals to provide quicker and more effective resolutions. I would say that this is desperately needed, especially in light of the current backlogs in tribunals, particularly south of the border. And no doubt the pressures already felt by our current tribunal system will be compounded by Labour's proposed reform. Moving on, as you would expect, Labour are also proposing to make changes to legislation affecting trade unions in order to strengthen their rights and protections. Firstly, unsurprisingly, Labour will look to repeal the changes made through the Trade Union Act 2016, which introduced higher ballot thresholds for industrial action, a time limit for industrial action following the ballot, and a requirement for more information on the ballot paper, as well as extending the notice of industrial action from 1 to 2 weeks. They also plan to repeal the legislation which gives the government the ability to make regulations providing for minimum service levels during a strike in certain public services, such as health, fire and rescue, border security. It will also abandon plans to reintroduce regulations that allow businesses to engage temporary staff during a strike. Labour are also seeking to simplify the process of statutory recognition by removing the requirement that unions must show that the majority of workers in the bargaining unit are likely to support their claim for recognition before the process has even begun, as well as changing the rules governing the final ballot, in which workers vote on whether to recognise a trade union, requiring unions to only gain a simple majority to win. Currently, in a recognition ballot, recognition will only be awarded if both the majority of employees in the ballot vote to recognise the union and at least 40% of the employees in the bargaining unit vote to recognise the union, which is a significant hurdle to overcome. Labour have also said that they will reform trade union legislation to ensure those working in the gig economy have a right to organise through trade unions, create a new duty on employers to inform employees of the right to join a trade union, and give unions greater access to workplaces for recruitment and organising. They also plan to introduce electronic and workplace balloting rather than simple postal balloting, as well as strengthen the protections for trade union representatives and blacklisting laws. These changes represent very significant reforms to trade union law and will mean that employers may see industrial action. Further, some employers who've never had to deal with union recognition before may well be faced with collective bargaining. As a result, employers who do not currently recognise a trade union may wish to consider whether they are at risk of trade union recognition and whether there is anything they can do to proactively engage with their employees on workplace issues, for example, via an employee forum, so that trade unions don't later fill this void. Management and HR will also likely need training on effective employee engagement and trade union rights. Very briefly, and separate to the Employment Rights Bill, the briefing note states that Labour will deliver a genuine living wage through changes to the Law Pay Commission and will remove the national minimum wage age bands to ensure every adult worker benefits. The new single enforcement body, alongside HMRC, will be given the powers necessary to ensure that the genuine living wage is properly enforced. Turning now to the second piece of legislation that Labour plan to introduce is the Draft Equality, Race and Disability Bill, which again is pretty radical in its impact. Its primary purpose is twofold. One is to extend the current equal pay regime so that it covers race and disability as well as sex, and secondly, to extend the current pay reporting regime for employers with at least 250 employees to include ethnicity and disability as well as gender. think it's fair to say that a lot of businesses will be concerned about what this means in practice. In respect of the proposed extension to equal pay, I have heard a number of well-founded concerns. Because of the complexity of equal pay legislation, a lot of the case law in this area gets bogged down in technical arguments about jobs of equal value, appropriate comparators, etc., which prevent quick resolution of the real issues at play and means cases can be stuck in the tribunal systems for years. This complexity gives rise to issues of access to justice, with it being much more difficult for employees to adequately represent themselves in such litigation. Questions also arise as to how you could find a comparator for the purposes of a disability claim. Would a claimant have to compare themselves with someone who doesn't have a disability under equality law, or will comparisons between different disabilities be permitted, and if so, how would this work? Similar and sensitive issues likewise arise when trying to draw comparisons amongst different ethnic groups. Furthermore, discrimination law as it stands already provides an employee with the opportunity to raise a claim for direct or indirect discrimination on the grounds of race or disability if there is unequal treatment. And unlike equal pay claims, compensation in discrimination claims can include an injury to feelings award and are not subject to any upper cap. So it remains to be seen whether extending the current equal pay regime rather than taking a different approach is truly the best solution. Similar concerns have been expressed in respect of extending the current pay reporting regime. Reporting on the gender pay gap is already a substantial task for employers, and extending this obligation to ethnicity and disability will clearly put a further burden on employers' time and resource. While some employers may have started work on ethnicity pay gap reporting following the government guidance on voluntary reporting last year, most employers will not have considered disability pay gap reporting. Difficulties arise in terms of obtaining the necessary data, and depending upon the size and composition of an employer's workforce, it may simply not have enough representation for meaningful reporting. Further, unlike gender pay, where two comparables can be more easily contrasted, both disability and ethnicity give rise to a number of variables within those protected characteristics. Therefore, without getting too technical, difficulties will likely arise in terms of how these subgroups should be defined, and this in turn will no doubt affect and has the potential to skew the results. Employers should consider what data they currently collect and how they will gather further data if required. Lastly, it's worth noting that previously Labour's manifesto mentioned the introduction of dual discrimination, that is, where someone claims they've been discriminated against because of having two protected characteristics. An example of this is perhaps where a woman experiences symptoms of the menopause whose claim may be more likely to succeed if they can show they've been treated less favourably as a result of both age and sex, rather than having to prove their symptoms either amount to a disability or their claim falling down if only one protected characteristic was relied upon. However, there is no mention of dual discrimination in the briefing note, so we'll have to wait to see if the draft Equality, Race and Disability Bill contains it once we see the detail. There were other changes mentioned in the King's speech and briefing note which will be relevant to employers, including the regulation of artificial intelligence and modernising and strengthening the Information Commissioner's Office. Interestingly, the briefing note does not address whether the Labour government will strengthen the new duty to prevent sexual harassment at work before it comes into force on the 26th of October this year. Labour had previously said that they would strengthen the legal duty for employers to make it a duty to take all reasonable steps to stop sexual harassment before it starts, rather than just reasonable steps as it is currently. Bit of a shameless plug, but we are hosting a webinar on how to comply with the new duty next month, details of which will be sent out with the bulletin following this webinar, so please do feel free to sign up if you haven't already done so. So one of the biggest questions you may be asking is, when is all this change likely to happen? Well, it is clear that the Employment Rights Bill is one of the government's key priorities. What is not clear, however, is whether they intend to table a draft before Parliament immediately or consult on it first. Either way, given their commitment to introduce it to Parliament within 100 days of them taking on office, we are likely to see quite a lot of movement in a short period of time. In contrast, as the reference in the briefing note is to draft Inequality, Race and Disability Bill, we expect that it will be longer before we see the detail of this bill. Nevertheless, even after it is introduced, it is not unusual for a bill to take some time to become law, given the rounds of parliamentary debate it is subjected to. Introducing legislation is only the first step in a process which includes a number of stages, including both the House of Commons and House of Lords being given the opportunity to debate and propose amendments to the draft legislation. Only once both houses have agreed the final content of the bill will it receive royal assent and become law, and this can take several months. Even once passed, it does not mean that any changes will come into force immediately, as they need secondary legislation or codes of practice to flush out the detail. And realistically, we think employment reform is not likely to be implemented until the end of next year at the very earliest. Interestingly, I did read the other day that the government already has the power to amend or abolish the provision in the Employment Rights Act relating to qualifying service. So they could, if they wanted to, make protection from unfair dismissal a day one right almost immediately without the need for further legislation, which was quite a terrifying thought. However, the reality is that to do so would put incredible pressure on the tribunal system, which is already stretched. So there are very good practical reasons as to why that wouldn't likely happen in practice and would actually be against the government's interests. In any event, we hope that the government would recognise that employers need time to prepare for the changes and the employment tribunals need to find resources to deal with more claims than ever before. Of course, we'll keep you updated on the progress of the changes. I'm going to catch my breath now and hand over to Vincent, who'll give a brief overview of Labour's proposed reform in terms of immigration.
Thanks, Kerry, for that. I obviously only specialise in immigration, but I always find it so useful to get employment insight, as there's usually a bit of overlap. So at this point, there hasn't really been that much insight from an immigration perspective as to what the Labour government might do. What we do know is that the Labour government have now scrapped the controversial Rwanda scheme. So for context, this was a scheme to remove certain asylum seekers to Rwanda for their claim to be processed there. But this was never really a concern for businesses. So what was actually covered in the King's speech then? So that goes on to my next slide, which is the Border Security, Asylum and Immigration Bill. So in comparison to the employment side of things, there was very little coverage about immigration. The Labour government do want to bring forward this bill, and so what does this mean? So the Labour government want to strengthen the border and make streets safer. They want to introduce and modernise the asylum and immigration system, and they want to establish a new border security command and to deal with and tackle organised immigration crime. So from that statement, it's a very broad brush, and there's not much real information as to what that means in reality, at least not from a business perspective. I do expect that any business-related changes would be dealt with through the usual course of the immigration rules, opposed to actual legislation. So at the moment, the focus of this bill seems to be fixing the broken asylum system and cracking down on organised immigration crime. The King's speech did also make reference to a Skills England bill. And so this bill, when it is enacted, would only apply in England, and the aim of this bill is to develop a single picture of national and local skills needs, working with industry and the Migration Advisory Committee. The Labour manifesto also discussed about wanting to reduce dependence on workers from abroad to fill skills shortages and to train from the local market, especially for sectors such as the health and social care and construction industries. So it seems that the Skills England bill will try and work on reducing sponsorship numbers in these and potentially other sectors by providing necessary training and support for those who are already in the UK. although, as mentioned, this bill would only apply to England. So it's not clear how this will actually interact with other parts of the UK and whether there will be discussions with equivalent organisations for Scotland, Wales, and Northern Ireland, given the skill shortages are UK wide, they're not just limited to England. Um, I would say from a pragmatic perspective, it might therefore be useful to assess current and future recruitment needs in the short term and over the next year or two, and perhaps look at whether it's worth speeding up and bringing forward the sponsorship timeline of candidates in case there will be changes affecting sponsorship. But I don't expect that there will be any immediate changes to the sponsorship regime. Um, the manifesto, the Labour manifesto, also talks about putting in appropriate restrictions on visas, as well as not tolerating abuse by employers of the visa system. And it also goes on to say that employers who flout the rules will be barred from hiring workers from abroad. So, given the recent surge in sponsor license compliance audits, and what has been said in the manifesto, I don't think it's far-fetched to say that sponsor license compliance audits will likely continue to be a common recurrence. So, off the back of that, I think it would be important and sensible to ensure that internal mock audits are undertaken sooner rather than later to ensure continued compliance with sponsor duties and obligations, and just to mitigate any potential shortcomings. Just a quick plug that that's obviously a service that we do offer at Burness Paul, and it is something that we can assist with. I had also mentioned just a few minutes ago about the Migration Advisory Committee. So, for those who don't know, they are an independent body that advises government on migration issues. And they recently published their findings on the graduate visa as well as the seasonal worker visa routes. And I would be surprised if the Labour government don't actually listen to and adopt the recommendations, and that includes keeping the graduate visa route, which will probably be quite a welcome move for employers who are wishing to hire recent graduates. So, what's on my immigration wish list? So, I think it would be nice to get a period of stability, given the vast number of immigration changes in recent months and years. And I do think that that will be the case, certainly from a business perspective. Um, I think it will be good to have the ongoing ability to recruit and sponsor migrants, especially in sectors with skills shortages. Definitely so before any potential changes to the ability to sponsor from abroad in line with any local skills and training policies can be properly implemented. So obviously any training policies will take time to implement. It will take time to train up the people. So that's why I don't think that there will be any immediate changes to any particular sectors, such as the health and care and construction sector. I think the Labour government have a good opportunity to have a review of the disproportionately high visa fees, and also perhaps have a look at and review potentially the recent changes to the skilled worker salary threshold, as well as the minimum income requirements for those applying for a partner or family visa. So, just to quickly sum up, I think it's probably sensible for businesses to assess recruitment needs and, as I said, consider bringing forward sponsorship timelines. And I think it would be good to assess current compliance with sponsor license duties and obligations, and just ensure that relevant personnel are aware on how to maintain a compliant sponsor license. So, as I've said, in terms of the immigration bill that that's been mentioned in the King's speech, I don't imagine that there would be any material changes that would affect businesses, and that any changes would be implemented through the immigration rules and changes to the sponsorship guidance. But I don't expect that any changes will happen imminently. So that's just my couple of pence worth of thoughts. Over to Ross to give an overview on some recent employment case updates.
Thanks, Vincent, and good afternoon, everyone. Now, I appreciate that Kerry and Vincent were the kind of spotlight for today, the main event, but hopefully you've still got some popcorn left because I've got some case updates here to share with you and some practical learning tips that we can take from them as well. So we'll kick off with the Johnson versus Bronze Shield Lifting Limited case. And in this case, the Employment Tribunal was tasked with determining whether failing to consider the effects of menopause when refusing a flexible working request amounted to discrimination. So the claimant in this case was employed as an administrator, and to allow her to attend a course on a Wednesday, she asked to amend her hours so that she could have the Wednesdays off and worked an hour longer on the other days. Now, this change was implemented and they had a 10-month trial period in which to see how things went. Now, prior to the end of this period, the claimant made a flexible working request, and she cited reasons being menopause issues and new caregiving responsibilities in relation to her elderly parents. And the claimant requested that she could work Monday to Wednesday, 9 till 5, but she wanted to take her 30-minute lunch break at the end of the day so that she could finish at 4:30, and then she would work Thursdays 9 till 1 and have a Friday off. Now, what happened was the employer denied this request, and they did so on the grounds that Friday was their busiest day and that there would be no cover for her. And they also didn't think it'd be worth recruiting someone for that one day. So they weren't happy with those points, and they also weren't happy with the fact that she'd be taking her break at the end of the day, because they said that legally every 6 hours she should be taking a break so that that could be done at the end of the day to allow her to leave early. So what happened next was that the claimant resigned, and she cited lack of accommodation for her menopause and personal caring responsibilities. The respondent offered a cooling off period and reminded the claimant of her opportunity to appeal the flexible working request outcome. The claimant countered with a very detailed letter, but this wasn't actually treated as an appeal, despite the letter effectively being an appeal. The respondent again offered a further cooling off period and the opportunity to appeal, but the claimant did not. The claimant then went to the Employment Tribunal, and she made several claims, including direct disability and/or sex discrimination, for failing to take her menopause into account when determining her flexible working request, and then for refusing that request. The claimant also made a constructive unfair dismissal claim in relation to both matters, alleging that the way the respondent had acted in failing to consider the reasons for the request breached the implied term of trust and confidence. Now, importantly, prior to the hearing in this case, the respondent did actually concede that the claimant's menopausal symptoms amounted to a disability, so that wasn't an issue that ended up going to evidence. The Employment Tribunal found in this case that the manager hearing the flexible working request had ignored what the claimant had said about the menopause when determining her application. And in fact, he admitted that it was because he didn't understand menopause. He also admitted that if the claimant had cited a different disability, for example, cancer, he would have considered that she might have needed treatment for that and therefore consulted HR. So the Employment Tribunal held that this failure amounted to direct discrimination based on disability, as a relevant comparator with a different disability would have been treated more favourably. The claimant was therefore treated less favourably because of her disability of menopause. However, the Employment Tribunal held that the actual refusal of the request was not direct disability discrimination, as it was based on legitimate business reasons and had nothing to do with her disability. I mean, as I mentioned, the respondent did ignore the menopause, so it couldn't have had anything to do with the request refusal itself. And the Employment Tribunal reasoned that they did not think a comparator with a different disability, but whose circumstances were otherwise the same as the claimant's, would have received a different outcome. And just to complete the discrimination picture, the Employment Tribunal also rejected the sex discrimination claim on the grounds that there was no basis to infer that sex was any part of the reason to refuse the request. What the tribunal did uphold, however, is the constructive unfair dismissal claim. And that was on the basis that the respondent's failure to take account of the menopause when considering the claimant's request for flexible working did breach the implied term of trust and confidence. So this case has several useful reminders for employers. The first, of course, being that if an employee indicates a specific reason for a flexible working request, this should be given due consideration. And if that reason is a health reason, then this should be explored further to fully understand the impact of that medical condition on the individual and the reason for the request. Employers should also always be alert to the obligation to make reasonable adjustments. Secondly, this case highlights the importance of menopause training for all staff, including managers. If the manager in this case had understood more about the symptoms of menopause and the adjustments that an organisation may be required to make, then this claim could have been completely avoided. And lastly, on this one, when denying a request, and as confirmed by the recently published ACAS Code of Practice on requests for flexible working, employers should consider alternative solutions and discuss these with the employee, which unfortunately the respondent failed to do in this case. So that's the Johnson case that we have there first off. And now moving on to Clifford versus IBM United Kingdom Limited. So in this case, it ended up being an employment appeal tribunal case, and they were considering whether an employee was precluded from bringing a discrimination claim arising after a settlement agreement had been signed. So Mr. Clifford had been absent from work continuously since September 2008. So in 2012, he raised a grievance against his employer, arguing, amongst other matters, that he should be transferred to the company's disability plan. So in 2013, the following year, a settlement agreement was signed, which stipulated that Mr. Clifford would move to the disability plan and receive a salary payment at an agreed amount. The settlement agreement included waivers for various specified claims, including disability discrimination. The agreement also covered future claims, i.e. those that had not arisen at the time the agreement was signed, but only to a limited extent. Specifically, Mr. Clifford waived such future claims which were connected to the matters set out in the grievance and the related appeal, or those future claims which arose out of Mr. Clifford's transfer to the disability plan. So that was in 2013. Now fast forward to 2022, Mr. Clifford is at the Employment Tribunal, and he's raised claims for direct, indirect and disability-related discrimination, arguing amongst other matters that since his transfer to the disability plan, he has not received any annual salary reviews in line with increases received by non-disabled employees, and there had been no increase to the level of payments that he had received. Now, IBM, his employer, argued that the Employment Tribunal had no jurisdiction to hear the claims, as Mr. Clifford had waived such claims under the settlement agreement. And the Employment Tribunal agreed. They struck out the claim on the basis that the claims were validly waived by the terms of the settlement agreement. But not wanting to take this line down, Mr. Clifford then appealed to the Employment Appeal Tribunal. And the question for the EAT was whether the agreement complied with the requirement for settlement agreements that's contained within the Equality Act. And that is that the contract relates to the particular complaint. And the EAT concluded that provided clear wording is used, there is nothing in the statutory language that precludes the settlement of future claims. Moreover, the statutory provisions include no temporal limitation on the kinds of claims that can be settled. The statute provisions simply regulate how parties enter into a statutory settlement agreement, but they don't contain constraints on the kinds of claims that can be settled. If that had been Parliament's intention, it could have said so. So ultimately, the EAT dismissed the appeal, holding that the claims were precluded by the terms of the waiver in the settlement agreement. Now, this is a helpful decision for employers, as there had been kind of some uncertainty recently concerning whether employees can waive future claims in a settlement agreement. What we would advise is that employers should be careful and look at the wording in their settlement agreements and their COT3s on a case-by-case basis to ensure that all future claims are waived insofar as is possible. What we expect to see and what we've been kind of discussing is that it's likely that employees might be trying to negotiate waivers concerning future claims a bit more, considering this recent development. So that's certainly one for us to consider moving forward. And then the final case that we're going to talk about today is the Valamula versus Al-Khair Foundation. And again, this was an Employment Appeal Tribunal case where they were tasked with determining whether it was unfair to place an employee in a redundancy pool of one and fail to consult with the employee on that decision. So the claimant in this case worked as a Masjid liaison officer, so an MLO for a faith-based charity. And this role involved fundraising in the community through, for example, schools and mosques. And at the time of his dismissal, the claimant was the only MLO at the Bolton branch of the charity, but there were 3 other MLOs employed in different locations. Now, I appreciate no one wants me to talk about this, but unfortunately this case does relate to the COVID-19 lockdown. So revenues during this time for the MLOs did decrease. So the claimant and the other MLOs were placed on furlough. And then following a discussion regarding potential redundancies, the claimant was one of 4 identified as being at risk of redundancy in the department. 3 consultation meetings took place and the claimant had been placed in a pool of 1 for the redundancy purposes, as the charity viewed his role as unique. And he was dismissed on redundancy grounds, for which he then made a claim at the Employment Tribunal for unfair dismissal. Now, Section 98 of the Employment Rights Act, it provides that, of course, a potential fair reason for dismissal is redundancy. And there's a redundancy where the requirements of the employer for an employee to carry out work of a particular kind or to do so in the place where the employee was employed have ceased or diminished or are expected to cease or diminish. So in this case, the Employment Tribunal found that there was a genuine redundancy situation and that the redundancy process was not so flawed as to render the claimant's dismissal unfair. Now, the claimant appealed this on the grounds that the Employment Tribunal hadn't sufficiently dealt with the issue of whether the charity had acted reasonably in not pooling him with the other MLOs in the other locations, and that it hadn't addressed his complaint that he was not consulted in relation to being placed in a pool of 1. And the EAT in this case did allow the appeal. It held that the Employment Tribunal had found that the charity had established that the requirement for the claimant's work had ceased or diminished, but did not find that the reason for the redundancy arose from such cessation or diminution of the need for work at a particular location. The EAT stated that the Employment Tribunal must consider whether the employer genuinely applied their mind to the question of the pool for which the employee should be selected and determine whether the pool selected came from within the range of reasonable approaches open to a reasonable employer. And the EAT, the Employment Tribunal in this case, had failed to consider those points. The Employment Appeal Tribunal also noted that consultation appeared to have taken place after the identification of the pool of 1, and it was therefore difficult to see how the consultation could have been meaningful. And as such, this rendered the dismissal procedurally unfair. So this case is a reminder to employers that when it comes to a redundancy situation, they must apply their minds very carefully to who should be included in a pool. Now, employers are kind of given a lot of latitude when it comes to the determination of pools, but consideration should be given to including employees at other locations, particularly where there is a proximity in the work locations. Consultation with the potentially affected employees should also take place at such a point in the decision-making process as it can be deemed meaningful. So that completes our roundup of the case updates today. We've had the Johnson case, which concerned the consideration of menopause for flexible working requests, the Clifford case, where we looked at the waiver of claims in a settlement agreement whilst employment is continuing, and the Valamilla case, where we looked at the redundancy pool of one and when you should consult on that. So that brings us back to Kerry to round us up.
Thanks very much, Ross. Very interesting. Well, as it turns out, we do have a few minutes for questions if anyone has anything. I can't see anything in the chat function, so hopefully that means we've covered things in a comprehensive manner and not just stunned you all into silence. But we are very keen to hear from you. You know, you are at the coalface when it comes to the reforms that are coming up. So please do feel free to get in touch. And obviously, as we have more detail in respect of the reforms and their timescales and the detail, then we'll let you know. Okay, no questions, but otherwise, thanks very much for joining us today and hope you have a nice day. Speak to you soon. Thank you. Bye.